This case is difficult, right? Because it's been in the news. We've all probably read about what happened, right? Please, once counsel gets the data.
Good morning, Your Honor. Christian Morris for the Plaintiff, Victoria Seaman.
All right, good morning, Ms. Morris.
Morning, I'm Peter Angulo, bond number 3672 on behalf of the City of Las Vegas.
All right, good morning, Mr. Angulo, and I think we have someone in blue jeans.
Yes, Your Honor. Good morning. Sigal Chattah, bar number 8264 on behalf of Michele Fiore.
All right, good morning, Ms. Chattah. Okay, Mr. Angulo, this is your motion, so I'm gonna let you argue. I'm gonna say it's very unlikely I'm going to rule on this today because it's very likely I'm going to ask for supplemental briefing on certain of the issues. Let me tell you where my head's at so that you can kind of shape your argument. On the negligent infliction of emotional distress claim, I think that under the Schaubry and then the Bartmettler case, I think the claim survives. I think you can have negligent infliction of emotional distress claims with, I guess, what you all are describing as a direct victim as opposed to a bystander. However, I'm happy to let you try to move me off that position, including why. And I understand there have been some cases from the Nevada federal court which have said Nevada doesn't allow these types of claims where you have a direct victim of negligence as opposed to a bystander. But frankly, I'm really not sure how those federal court judges came to that conclusion in light of and if I'm saying this right, the Schaubry and then the Bartmettler case. On the civil conspiracy claim, I think, and I'm gonna put a pin in this for a second, I think that with the exception of the possible application of the intracorporate conspiracy doctrine, I think the claim has been pled for 12b-5 purposes. Here's my problem with the intracorporate conspiracy doctrine, as well as, and we're gonna get to this in a minute, especially with the supplemental briefing, with the employment discrimination claim, you can't have it both ways, okay? Either these council women were employees and agents, or they weren't employees and agents. But I don't think you can have it both ways and use it one way for one claim and use it as a shield for one claim and use it as a sword for another claim. So that's where I am on the civil conspiracy claim. Also, I'm not entirely sure 651.105 applies here because I think that statute is very specific to hotels, inns, boarding house, places of abode or temporary abode. And then kind of going to I'm skipping ahead. I'm skipping over the negligent security and negligent hiring claim for a second. But going to the employment discrimination claim, this is what I'm probably going to ask you all for some supplemental briefing on. I don't know. I've really struggled with this. I tried to do a little bit of my own research in preparing the case for this, but the answer is it depends. When I'm looking at other states and other, let's say, rights schemes, such as the ADA, such as the Age Discrimination Act, such as Title VII, such as state corollary acts to our employment discrimination acts, what I'm seeing is it depends on the state. I know that under Title VII is actually, if you were alleging a discrimination claim under Title VII, it would be easy because they actually specifically exempt public officers from the definition of employee under Title VII. And I looked in Chapter 613 here. While the legislature very helpfully defined employer, they very helpfully do not helpfully define employee in this instance. And so I'm going to need a little bit of supplemental briefing as to, okay, and I think you're going to have to look at persuasive authority from other jurisdictions, looking at our scheme, looking at the meaning of our scheme. Would public officers, whatever employee means, right, since it's undefined, whatever employee means, would elected officials and public officers be accepted from the definition? of employee. I just didn't see a whole lot, I read the cases that you all cited, but they weren't entirely, they didn't give me much to go on. So I think I'm gonna need a little supplemental briefing on that. I'm also gonna need a little bit of explanation, and this goes to whether or not I dismiss this case, or sorry, whether or not I dismiss the employment discrimination claim with or without prejudice is, okay, let's say counsel, for purposes of the type of discrimination that's being alleged, a counsel person fits within the definition of an employee. Well, now how does the Nevada Equal Rights Commission and the requirement to, exhaust your administrative remedies, how does that fall through? Ms. Morris, I know you said in your briefing, you all tried, right? Obviously, that's not in the complaint. Correct. And so I don't really know what you all tried. I'm assuming you tried and they were like, no, you're not an employee. That's my best guess, or they rejected it. But I have no idea what happened with the Nevada Equal Rights Commission. So I need a little bit of explanation overlay on that. But sorry, I've been talking for a while. This is your motion, Mr. Angulo. Okay, I'm sorry. I really like to try to get things right. I'm horrible at it. This is your motion. Let you argue and make your record.
I'll just do it briefly, Your Honor. I appreciate the questions, and it appears that we'll probably have to do go back and do something with it. As to the NEID, the simple truth is she can bring emotional distress damages on the event itself as a direct party, or a direct victim.
Right.
But if it's a question of her long-going relationship with Ms. Fiore, NIED, like IED, with the sole exception perhaps of a medical negligence case, where say parents are watching a child slowly wither and die over a period of time. It is a one-time event. It's an immediate event, and there isn't anything here that reaches the level of the standards for an NIED to come into play, even if the party can hold it directly.
Would you say even based on, this case is difficult, right? Because it's been in the news. We've all probably read about what happened, right? But at this stage of the case, on a 12b-5, I gotta look at the pleadings itself, and it's a very low standard at this point. And maybe at the end of the day, Councilwoman, Seaman won't be able to have the evidence to prevail an IED claim, but at this stage, that's not what the court's deciding.
Correct. However, as we pointed out to the court, in their pleading, in the section dealing with the NIED, there aren't the kind of severe emotional distress damages that are required to have an NIED claim go forward. She says she had suffered emotional distress or pain and suffering or whatever it was. And so, respectfully, Your Honor, and we can disagree, and that's fine. I don't want to belabor that with the court. As to the civil conspiracy, and really to that list of employment, just briefly, we'll supplemental brief that as the court has directed. But an elected official, city council person, the city doesn't control any aspect of the hours they work, of whether they go to the meetings or not. The city itself is powerless to enforce that. That's done at the city council level. And so the city itself they don't set their salaries. They don't give them how many vacation days they get. There's no negotiation for that. They're simply an elected official. They are the organization itself. And so that we got the employer, Elon Musk, suing Twitter for not treating him correctly. He owns the company. He can't not treat himself properly. And that's really what you're looking at here with this employment discrimination. As to the civil conspiracy, she doesn't have to be an employee for the intra-corporate conspiracy theory to still apply. She is the city. As a city council person, Ms. Fiore was the city. They're moving arms, the force of the city itself.
Well, how can she be her own entity and the city at the same time? This is why I have trouble with being able to use that same argument for both claims.
Well, respectfully, Your Honor, that's what it is. She's not, in a sense, she's not separate from the city. She is the city. She is very much they're a city. Like the President of the United States represents the United States, It's indivisible while he's in office. And so for the same thing that happens for the corporate conspiracy. Since she is the moving authority of the city, she can't conspire with herself, which is the city as a theoretical municipal entity. Since she is very much the integral part of that, of the actions that it takes, its arms, its hands, its eyes, as it were. Without legal speech, she can't conspire with herself. Because there's any question, she's a part of the city. But it's because she's a part of the city, just because she's a part of the city doesn't mean she's an employee. That's the unique part of being an elected official. I think the one case we cited said that the only employers that she has are the electorate, the people that put her in office. They decide whether she keeps her job or whether she doesn't keep her job.
So let me ask you a question, okay? So I'm gonna take this out of the city context and let's go to the legislative context for a second. We all agree legislatures, elected officials, right?
Correct.
But certain legislatures, for instance, I assume perhaps the majority leader, minority leader, so on and so forth, they determine, for instance, committee assignments, right?
Correct.
So what happens, for instance, if they decide, we're going to stack the committees with all men, we're not gonna put any women on the committees? What's your redress then, as a legislature? Like, for gender discrimination, who do you get to sue? Or do you have to just suck it up? And this is the lot that you chose when you were elected.
I don't know, Your Honor, directly whether there's a law that would allow a female member of the legislature to say, I'm being discriminated against because only men can be here. I think that would be a matter she would take publicly, and if she galvanizes the electorate and they think that these gentlemen are acting in a discriminatory manner, then they don't re-elect her. I don't know that there's any harm to someone not being on a committee or to being on a committee. There's no pay raise that goes with it. There's no benefits, just more work to do. Maybe you want the authority and the power of it, but the simple truth is there's not a damage like there is in an employment context where you're saying, listen, I'm foreclosed opportunities of advancement where my salary's increased or where I can work my way up to a different department or something like that. As a member of the legislature, you are what you are. You're an assembly person, you're a senator, you're a congressional representative, and you stay in that position until you're no longer wanted by the people who put you in that office. And so respectfully, Your Honor, I do think it's a different analysis. I don't think it's an either or. I think you can have both. You can say you're not an employee of the city, but you are an indivisible part of the city, and therefore you can't conspire against yourself. And then briefly, Your Honor, as the two negligence claims, respectfully, I think I briefed it enough, and I'm afraid my throat will go out here pretty soon. But if the court has specific questions on that, I believe that's going to be accurate. I would let the court know, though, in anticipation, if the court denies the request on immunity, we will ask at time court for an interlocutory order because immunity is immunity from the cost of suit. We want to go to the Supreme Court and see if we can have that resolved. I'm just letting the court, I don't want to threaten the court or do anything like that. I'm just letting the court know that would be my intent, that we would do that. And if we did it in an oral argument, the court wanted it in writing, we'd be happy to.
When you say you want to, you want me to try to do a 54B certification, or do you just want to try to rip me? Either way is fine.
No, I think it would be a 54B certification. Okay. I know that in federal court, on issues of qualified immunity or absolute immunity, that's the way the court handles it. It's basically a 54B.
Okay.
Set it up because of the issue, because of the protection from the cost of suit, as well as the exposure to damages. And I haven't, I'll be honest with the court, I have not looked at that and see whether Nevada treats it differently here. But I will do that before we.
Yeah, can you put that in your supplemental brief as well?
I will be happy to.
Okay, thank you.
And with that, Your Honor, unless you have another question, I'm going to sit down.
I don't.
Thank you.
All right, Ms. Morris?
Good morning, Your Honor. I apologize for the sniffles.
It's okay.
My son brings home a new cold every time he goes to school. So, a couple of things I just want to hit on, respecting what you've said and knowing that you need the supplemental briefing. But I think it's pretty clear from the cases that you talked about. And also there's Olivero versus Lowe, which there can be an absolutely recognized NIED claim in an employment case, period. And all you have to have is either proof, and this is when you're actually in the case, proof that there's emotional distress or physical injury, which this is a 12b5 motion. I mean, this is what did we plead? She clearly had physical injury from this.
The way I read Bart Mettler is that what you need is, you either need a physical impact, which from the city, there's no physical impact, so.
Well, that I would disagree with, because he just argued that Michele Fiore is the city. And
Well, that's interesting,
And that's,
actually.
I think that's why it comes, then you speak to it, she has her own counsel, and yet he argues she is the city. And therefore, every move that she makes is the city, and a physical impact in which we are alleging that if you look at it as an employment discrimination case, and this is the argument that we've made, if you look at what the case law is, and the Supreme Court talks about when you look at what employment is, you have to look at the master-servant relationship. And so when you look at the master-servant relationship, you have to look at the length of it, the amount of control, and we allege that very clearly. There was control as to whether she could be moved off that committee. She asked for protection. She was not provided protection. She was in fact not provided protection, and her aggressor was given the ability to move committees when asked. You have to look at the control of it. She had to ask permission. She was denied. That shows control. And when you look at the master-servant relationship, that's the common law analysis in Nevada. And the Supreme Court case, Nationwide Mutual Insurance versus Darden is really kind of on point on that, in what the analysis is for the master versus servant relationship.
Ms. Morris, let me just go back, let me just stay on the NIED claim for a second. I mean, you would agree, so I know counsel argued very eloquently that the councilwomen are the city. I'm not sure if I accept that, but presuming I don't accept that, you would have to agree that there's no physical impact, right?
I would agree that there was physical impact from Michele Fiore.
Right, but not from this, presuming they are separate,
Yes.
that there was no physical impact from the city.
And I would agree that we have alleged in the case both IIED, intentional infliction of emotional stress, and NIED, which is when you look at what the standard is, you have to look at what was alleged, and was it a claim in which relief can be granted.
But you have, I think you have alleged that, I mean, so you either need physical impact or the second part, which is you need serious emotional distress causing physical injury or injuries to be present. And I think, to me, I think you have alleged that at paragraph 117, where you say, as a direct and proximate result of the negligence of the city, ... Councilwoman Seaman suffered physical injuries and bodily pain, humiliation, emotional anxiety, mental anguish, so on and so forth.
Correct.
And that's just, I mean, we're at the notice pleading stage here.
Exactly.
And what I'm constrained by Rule 8. This is not, we're not in Twickball land, we're not in plausibility land. So, for me, I think that if anything survives, I think the NIED claim is going to survive. What I'm really interested in are all of these other claims here, including, and I want you to also talk about discretionary immunity a little bit, and then I'm gonna let the city's council have an opportunity to respond.
So I think what's important about the discretionary immunity claim in this case is to look at the actions, because it really flows into the employment discrimination case, of the city after they have a reported crime on their property. They had a reported assault and battery. Now, the discretion, we don't have all of the evidence of everything that they did in their, quote, investigation. And we know that they destroyed the videotape. Now, what would be the discretionary immunity in their failure to properly investigate and failure to preserve information that they know is vital to a crime? Where is that discretionary when you know there's a reported crime on your property? Where is there some sort of social policy or some sort of interest in destroying the evidence of a reported crime? So when you look at that, how in the world does that fall into any kind of discretionary immunity? Knowing a reported crime, having evidence of the reported crime, what exactly are their duties? And we know that they have control, because under NRS 266240, they can punish or expel any member. And they can do that by looking at disorderly conduct, and they can expel the member for cause. They have the power to do so. What they did, their choices that they made. Yes, it's NRS 266.240. Rules, punishment or expulsion of members. The city council shall determine its own rules of procedure, may punish its members for disorderly conduct, and with concurrence of 2/3 of the members of the city council may expel a member for cause. Do we know the details yet of why they chose to take the actions when they did, when a crime occurred, a reported crime, and chose not to do certain things and then to destroy the evidence does not fall within discretionary immunity and flows directly into our claim of employment discrimination, because it is unfair to rob her of the evidence of her attack and then to fail to move her, continuing on to safer committees, and yet when Fiore asks to be moved, she is moved. And so those have to be read together. This is a totality of the circumstances case, and we are at the initial pleadings, where we don't have all of the information. But to say that they have the discretion to just ignore it, and that there's some policy that would protect them from destroying evidence of a crime is far outside what discretionary immunity means, and doesn't fall within this case or the actions of the city.
You mentioned it a little bit, the whole master servant argument that you're making as to why there can be a claim for employment discrimination here. I mean, how much of Ms. Seaman's actions or decisions does the city, and by the way, I'd like for you to tell me who you think the city is, right, who this entity called the city is. How much of her actions do you think the city controls?
Ms. Fiore's actions or
Ms. Seaman's actions?
Well,
Or either one, I mean, they're both,
yeah, and I think it's
a council person's
absolutely.
actions.
I think it's very clearly alleged, and that's why I brought up the case that I did of Nationwide Mutual Insurance versus Darden, because you have to look at who has the power and control. And that's why we clearly alleged that she said, I need to be moved, I am concerned, I'd like to be moved off this committee, I'd like to be separated. The separation didn't occur because the permission wasn't granted, and that shows the control. And so for me to stand here defending a 12B5 motion with not allowed to do any discovery, based on what I have for the information was properly pled, is the city, which would be the mayor that she was consistently asking for help from, pardon me, that was denied, has the master-servant relationship with Ms. Seaman, because she's asking permission, she's being denied, she's told what committees that she needs to be in, and she's told what committees she can't be removed from. And for him to say, well, there's no consequences if she doesn't attend, none of that information is in this case right now. We haven't even begun discovery. No one can pretend to know what goes down at the city and city councils, but we're looking at what's been properly pled. And in this case, she's requesting the mayor, she's telling the city, she's telling the city attorney, I was assaulted, I was injured. She's telling her, quote, employer, what happened to her on the property. And they're the ones in control of the evidence, they're the ones in control of the investigation, they're the ones in control of where she can sit and what committee she needs to serve on. And to say that isn't some sort of master-servant relationship, I believe the city is her employer, a separate entity. Michele Fiore also gets to ask the committees what committee she can be on. She also has that master-servant relationship with them. Now, she gets to be moved when she asks, which is where the discrimination claim comes in. And so when you look at what we have pled, it is clear that Ms. Seaman cannot just come and choose as she pleases. She can't just move committees on her own. She has to have permission. She was asking permission for protection. She reported the crime. And so for them, they have a duty then, as an employer, to properly handle a crime that's occurred and to preserve the evidence, which goes into the civil conspiracy of destruction of that evidence. So that's how I see it. Now, the law, as you very clearly stated, does well define what an employer is, but what an employee is, you have to look at what the relationship is, who has the control, the duration of it. Can you just not come in and do absolutely nothing? Is it outside the scope of which you are in your position to be, which she serves as a city councilwoman, she's qualified to be there, she's there doing her job. And for him to say that the only people that Fiore answers to are her constituents, that's not true. Because in fact, you can expel, the city council has the power to expel Fiore if she has misconduct. It's not the constituents who have that power.
You can't remove her from her position, right?
They can expel her for cause. So they have the power to do that. And so for him to say, her constituents are the only ones who can say it, that is not what the law in Nevada is.
Okay. We just usually have statutes pulled up. Let me pull up that statute.
266.240, rules, punishment, or expulsion of members.
So the council can expel a member for cause, right?
Correct, they have the power.
Interesting. Okay. All right. Anything further, Ms. Morris?
Nothing from me, Your Honor, in the exception of obviously I will be happy to provide a supplemental briefing. I'll obviously allow him to respond with whatever he needs. Do you have a timeline on the supplemental briefing? When you'd like that submitted?
Well, we have we're rolling into the holidays,
Yes.
right? End of the first week of January would be fine.
That would be great.
Okay, is that okay? Sorry. January 6th?
Do you want them simultaneously filed, Your Honor?
Yeah.
Okay.
Simultaneous briefs.
And sorry, what date did you say, Your Honor?
January 6th. Can we do an in-chamber status check for January 6th? For the supplemental briefing. Okay, reply.
Briefly, Your Honor. All deference to counsel. She keeps jumping to what the complaint says and what the law is. The statutory framework of NRS 266 makes it clear that Ms. Seaman is not an employee of the city. Because the city council is the one that determines everything about whatever they're going to do. Where they work, whether they attend meetings or not. In fact, if they get punished, they don't attend meetings, so apparently absenteeism can be an issue, and the city's powerless to do it. The mayor is also relatively powerless in this. She makes sure the contracts are signed. She makes sure by statute that if she needs to break a tie vote, she can do that. But nowhere is she given the authority under either the city charter or the statutory scheme to be the one who decides where people go, whether they can get a different meeting. The complaint itself on that issue says that the decision was made when she made the request. Nobody else on the city council, I guess, wanted to cooperate. They couldn't make those switches. And logistically, they couldn't get her a third party at the time. That's, to the extent that she ever does not discretion, of course it's discretionary. That's the whole point, is some analysis that takes place as whether they can do this or not do it for whatever reason it is. Same thing is true with the investigation of the crime. There's no law that requires an employer to investigate a crime. That's done by the police, that's done by perhaps with the assistant of the district attorney's office, or city attorney's office. But that's an investigative aspect of the crime. The city doesn't conduct those, the police do that. But more importantly, this master-servant relationship, again, just simply isn't supported by the statutory framework that's given. As to the destruction of the videotape, again, the complaint makes it clear that this was a pre-existing policy. It wasn't unique to this case. It's part of the city's standing policy on these videotapes for whatever reason. The parties were notified that if there wasn't a formal request for the videotape, that it would be destroyed in 60 days. The complaint makes that application and is absolutely silent as to whether anybody made a formal request for it. In the absence of a formal request, it was destroyed. That doesn't take it outside of the realm of discretionary immunity. Because as we've indicated to the court, there are a number of factors that determine whether you can keep all the video surveillance tapes that go on. In this courtroom, I can promise you that they have a destruction policy. They simply don't have enough space to keep all of the videos that ever occurred from the beginning of the time the court was held about cameras and before. And so that's not a matter that takes it outside the realm of discretionary immunity. And with that, Your Honor, we'll go ahead and prepare our briefs on these matters. I guess, we got one other point on the NIED claim. And that's the question of, where's the duty of the city that's breached to create the NIED, right? In other words, it's great the event happens, but the question is, where's the duty the city had to somehow stop this, two people from fighting with one another, two people from being unkind to each other? What was where was their duty under the law to involve themselves in this? And respectfully, Your Honor, I don't believe that's been asserted or more than can be established. We'll brief that in addition.
I'm going to go back to Ms. Morris for just a second, because on that last comment, and then I'm going to let you have the last word. Don't worry, it's your motion.
I need to word your own thing.
My understanding of your NIED claim, it isn't so much about Ms. Fiore, although everything is, I should call it, excuse me, so my mind wandered for a second. It isn't so much about Ms. Fiore as it is about the city's actions. Am I understanding your complaint correctly? The way I read it, it's about, their alleged destruction of the evidence. It's their failure to, switch to committee assignments. It's their negligent security. These events or non-events surrounding the incident at issue. Am I reading that correctly?
You are, absolutely, and that's the way it's alleged. You have to look at the totality of the circumstances and we look at the foreseeability of the issue. Because his argument kind of plays to what you just said, is, well, what if they just stack a committee with all men? So you can know that there's something coming down and someone can be complaining and I don't feel safe and I'd like to be moved, and there's just nothing anyone can do about it. And so that's where it comes in, is where in an employer situation where we have an employment discrimination claim, in an employment case, negligent infliction of emotional distress claims are recognized, which is what we've alleged in this case against the city, very clearly, because it ties to our employment discrimination case in the employee-employer relationship.
And counsel, that was my understanding. Are you reading the complaint differently? Is there something that I should focus on that should make me think that the plaintiff's NIED claim is really about the physical impact caused by Ms. Fiore?
Well, no, Your Honor, but what I would note to the court is this: all of those things that she listed, how you display security, whether you move somebody off a committee or not, those aspects, to the extent that they're considered negligent, I respectfully submit to the court, they're protected by discretionary immunity. They're covered by that protection because those are all decisions that are made as to where you marshal your assets. Who's best on a committee, who's not best on a committee, what's best for the operation of the city going forward. And to the extent that those decisions are made, whether by the city council, or the mayor, or city manager, for all I care, they're protected by discretionary immunity. So that's what I said to the court was, before you can get to the IED, you've got to show a breach of the duty that leads to negligence that creates the situation. And here for the city, there's nothing that they've done that they had an obligation to do, for which is not a protection of discretionary immunity.
Maybe you will kind of educate me a little bit. I'll give you an example. For instance, I'm a state employee, but this county is required to provide us these, the furnishings, the building, all of the stuff for the district court judges to do their job. What is the city's obligation vis-a-vis the city council? What are they supposed to do? Are they obligated to provide the meeting space, the chairs? What's the relationship then between the city and the city council people?
I think statutorily, the way it works is the city council determines what it is they need, and they direct the city and vote on it. If they need a new building, they're the ones that decide. If they wanted to move their marshals out of this court building and move it over to their own new building that's fancy and sweet, they get to do that. If they vote on it and if it needs to be passed by the electorate, then they do that. But otherwise, if it's within their ambit, they determine.
And this goes back to your argument that the council women are the city, or the council people are the city. Unlike, for me, I'm at, I serve at the pleasure of the people, but I sort of have to wait for the county commission to give me, a jury box, for instance, which I don't have.
But statutorily, I think that's right. There's a division of how the courts handle. However, there's case law out there. I think it's Danes, I could be wrong,
Okay.
where that issue is raised. Is a judge an employee of the county, of the city, or of the state? And the Supreme Court said you're state. You're protected by all the immunities that apply to a state employee.
Right.
You're just assigned to this location and you work within the ambit here. But this court controls, for example, the actions of its marshals. If you didn't want a bailiff in this courtroom, you make that decision. The county doesn't say to you, well, you're keeping them whether you like them or not. That just doesn't happen that way, correct? You decide who your staff is going to be and so forth. that's not appointed to you without your input and permission. And so and that's a different animal because the city council is, again, the moving part of the city. In the example you're giving, you're a state entity that's nested within the county, performing the state function, the judicial state function, but to the members of the county here.
Sure. Okay, anything further, Ms. Morris?
No, just briefly, and because we're here on this is a motion to dismiss and how it's pled. If it was pled that she could leave and move around and do whatever she wanted, then there would be no, I'm going to the mayor and asking permission to be moved, and I'm being told no. No, I can't, no, I have to go. And then I see requests from someone and they get moved immediately. It's not like she can just choose which one, and he's making it sound as if that is what has been pled in this case, which it is not. And in our brief, we will very carefully look at the Martinez case, because Martinez talks about discretionary immunity. And in that it says certain acts may be discretionary, but do not fall under the discretionary function if they involve negligence unrelated to any plausible policy objectives. And so what plausible policy objectives is the city saying by not moving her? What plausible policy objectives is it to delete a video with a crime on it? Are they just there's just too many of these videos that they can't hold on to it? What's the policy objective that they're saying for their actions? And so that's why it's important to look at the complaint has been pled, because these questions that he's raising, the control that he's talking about, is not what has been pled in this case. And if it comes out in discovery, maybe it's more appropriate for a motion for summary judgment to be looked at once we actually have that information, because what he is saying is outside the pleadings. And that's what a 12b-5 is, to look at what's been properly pled in the case. And if the perception of the employee is that they cannot do what they want without permission from the master, without going to ask for permission, by being told no, that's an employer-employee relationship. Not that you can just go do whatever you want, which is what he is saying to this court today, which there's no evidence of yet in this case.
Last word?
I hope this is our last word, Your
It
Honor.
is. It's
Thank
your
you
last
very
word.
much. I appreciate it. In all fairness, it's improper to argue that on a 12-5 motion that you're stuck with whatever the complaint alleges. If it was a matter of law, it's an inappropriate allegation. If she alleges she's an employee, but as a matter of law, she's not an employee, you don't get to say, well, I guess we'll have to do discovery and figure it out. The law already establishes whether she is or isn't. I'm not arguing, I've never argued to this court that the complaint says anything other than what it says. I'm personally trying to be very, very specific about that. What I have said is that despite what they made the allegation of, the law itself, the statutory framework, the city charter, isn't supportive of it. The law tells them something different than what they're alleging. I don't really care what they're alleging. Frank, I don't care whether it's true or not true. At this point, that's irrelevant to me. The question is whether as a legal matter it applies. Because if it wasn't for that, then you'd never have a motion to dismiss. Right? You wouldn't, under Fourth Amendment, let's say, if you were doing federal court, you wouldn't be able to argue that the Fourth Amendment doesn't apply in a situation because somebody wrote in a complaint and said, no, I said my Fourth Amendment rights are violated. You have to accept that as being true, and therefore I avoid all, let's do discovery.
I agree with you. There have to be facts which, taken as true, leads to a cognizable claim that the law recognizes.
And that's all I said.
No, 100%. I agree with you, and I don't think Ms. Morris disagrees with you on that. I think she just disagrees with you on what the law is. And so I agree with that. Yeah. And
Most
so, let's get the supplemental briefs in. Obviously, brevity is always appreciated, but I think this is an issue of first impression. I haven't found another Nevada case on this issue of, what constitutes an employee, at least in this context, in the elected official context, under 613. So, while certainly, be as brief as you can, don't hold back on giving me cases from other jurisdictions that you think I should follow, and tell me why you think I should follow them.
Okay, sounds good.
All right, thank you very much.
Appreciate it.
Great argument, great
Thank you
briefs.
very much.
Thank you.